Hello and welcome to this edition of the Ask Alan television program, the show that discusses issues in wealth management, taxes, estate planning, and investments. This is a show in which you are invited to call in your questions to our guest on tonight's topic, and that phone number is 973-4209. We appreciate you tuning in for tonight's show. We think we have a great topic. It's the pros and cons of living trust. And to discuss the topic with me is local attorney Tom Seal. Tom, welcome.
Thank you, Alan. Appreciate it.
Well, we're glad to have you on. We do have a very interesting topic, and before we get into the topic, I think it'd be good for you to share with our viewers a little bit of your background and your credentials, the type of services you offer, and the clientele that you serve.
Sure, I'd be happy to. I graduated from Indiana University, undergrad, and then I went to Indiana University Law School, and then I completed my graduate work at Harvard University, and then at that time I went to the Air Force as a Judge Advocate General and worked there for 4 years. Then I left the Judge Advocate active duty and got into the Air Force trial team, spent 3 years there, and then went to work for General Motors for 2 years, and then since that time, since about 1990, I've been practicing as a sole practitioner here in Richmond. And pretty much just focus primarily on estate planning, probate, and a little bit of Medicaid planning. Mm-hmm. And so the clientele is, basically individuals, some businesses. We do some business planning as well.
Good, good. So you're well qualified to talk about tonight's topic, right?
I hope so.
Good. Well, we'll dive right in, Tom, and of course we hear that word living trust bandied about all the time now. It's become a very popular estate planning tool, and I'm sure our viewers would be interested in knowing just, what is a living trust?
Well, a living trust basically is a trust you create while you're alive, as opposed to, let's say, a testamentary trust, which is a trust that's incorporated within your will. And a living trust can be a revocable trust or an irrevocable trust. And most of the time, the best way I've ever heard it described is effectively what you're doing is you're creating a box. And in this box, you identified a set of instructions. So let's just say this is a box here, and then you identify a set of instructions of what you want to occur while you're alive, and then obviously after you've died. And so you put that set of instructions inside the box, and then you identify a trustee. And while you're alive, generally, you're going to be the trustee. And upon your death, or whenever you decide to no longer serve as a trustee, you're going to have a backup trustee. But anyway, that trustee basically climbs into that box and follows those instructions. When you die, or when you become incompetent, those instructions become irrevocable. And then, so now you've got a real pretty box, you've got a great set of instructions, and you've got this really good trustee, but it won't do you any good unless you actually put your assets and transfer your assets in the trust. And that is what is effectively a good estate planning tool, is to go ahead and create this trust, set your instructions the way that you want to, identify a good trustee, and transfer your assets in there.
I know that living trust has become a very popular estate planning tool in the last 10 or 15 years. And what are some of the reasons that we're seeing it used more and more by individuals for their estate planning?
Well, primarily because it's an excellent problem solver. If you have a blended family, for instance, you're on your second marriage or something, and you have a blended family, you can actually use a trust, obviously, to take care of your children from your previous marriage as well as your current spouse. So that's an advantage. There's a number of others. It minimizes or totally eliminates, or can actually totally eliminate your probate cost and the need for probate. So that's a good thing, because again, while these assets are in the trust actually owns these assets.
Okay.
And the reason for probate is to transfer the assets from the person who died, the decedent, to the living. And if the trust owns the assets, then basically the trust doesn't die, and so you avoid probate that way. Another thing is it also allows you provisions to help disabled individuals, and perhaps even helping them to an extent that it will not affect their government entitlements like Medicaid and the like. So with a special needs trust, that you can use that. So that's a real good thing. It allows an individual upon his death to effectively sprinkle his assets to his, let's say, to his children, the same way that would happen if he were still alive. So for instance, if you go to the store and Johnny needs shoes, well, you're going to buy shoes for Johnny, but that doesn't necessarily mean you're going to have to buy shoes for Susie. You're going to pay for those, what's needed at that time. And so when you die, that allows the trustee to do that as well, to sprinkle the assets to the individual beneficiaries as they need them. So for instance, if someone has a medical emergency, then they could take more than perhaps their equal share.
Right.
And so you would treat them equitably as opposed to equal.
So it has a variety of purposes that it can serve to help someone do their estate planning.
Absolutely. It can serve to incentivize or disincentivize certain activities. You could identify, for instance, if the child receives a 3.5 grade point average in his college, then he'll get this amount. If he receives a 3.0, he'll get this amount. If he goes to jail, he won't get anything. So there's all kinds of neat things that you can do with it.
Well, one of the things that you mentioned in the way of the benefits of the living trust is avoiding probate. And share with the viewers exactly what is the probate process and why is it now that so many people are trying to avoid that process?
Well, there's a lot of things. People shouldn't be inherently afraid of probate because probate is not inherently bad, but probate can be expensive, can be time-consuming as well. In Indiana, currently, you have to allow a probate estate to be open for 3 months. So the procedure would be effectively is that obviously an individual dies. And then so what would happen is that they would have to submit a will to the court and along with a petition to open up the estate, the probate estate. At that time, then, the court appoints a personal representative. And then this personal representative is responsible to gather the assets of the probate, of the decedent's estate, and to identify all the debts, to notify the creditors that they do know, and to publish the opening of this estate in a newspaper. From 3 months from the date that that's first published in the newspaper, the estate has to remain open. So therefore, you're very likely not to be able to make any distribution or else somewhat limited distribution during that 3 month period. It's also a public document, so individuals could in fact identify, and the will could be published or will be published. And so if someone with a need to know could actually find that out, whereas a trust is pretty much confidential. There's also the fact of will contest that you have to encounter, or that you may have to encounter. But during this 3 month period, you have to wait until all the claims are filed, decide whether or not to pay those claims. If you do pay them, or if you pay part of them, then obviously you might have to have a hearing in order to determine whether or not the full claim should be paid. You also have to pay the last expenses of the decedent, his last medical bills, funeral costs, and the like. Those should all come out of the probate estate. Inheritance taxes, federal estate taxes, those have to be paid before the estate's closed. Pay the cost of administration of the estate, including attorney's fees. And then obviously he has to file a final accounting with the court to identify this is what we came into the estate with, this is what we spent, this is how we spent it, and this is what's left to make the distribution. All that is basically the probate system. Another way to kind of describe it is basically an individual dies and he has assets. Okay.
Right.
Now, some of these assets may not go through probate. Some of these assets may be held jointly, perhaps, with his spouse, with a right of survivorship, or with someone else with a right of survivorship. And in those instances, then that asset will go ahead and transfer to that individual.
Automatically.
Automatically. You don't have to go through probate. Same thing with other things, beneficiary designations like life insurance and IRAs and things like that, pension plans. Those will go by contract. Those will go to the designated beneficiaries, and again, avoid probate. Another advantage, another example of that would be a POD account, a payment on death account. Those things bypass probate and go straight in. And again, of course, obviously, those assets held in trust, they will avoid that. But basically, so those assets that the individual holds, let's say his car title or whatever, land that he owns privately or individually rather, those are the assets that will have to be transferred through probate. And so what happens is the individual dies, he has these assets, and here are the people that he wants to receive them upon his death.
Right.
Obviously, he can't sign the deed anymore, he can't sign the title, so the court has to step in and make sure that that's done properly. And so that's what happens. And then, so when the decedent dies, you need to build a bridge between the decedent's assets and the individuals, the beneficiaries, the heirs. And that's what probate does, is effectively builds a bridge in order to allow these assets to be transferred to the living. And unfortunately, there's this troll underneath the bridge. It's called an attorney, and the administrative fees that sometimes grabs those. But obviously, in addition to that, though, there are people that can file claims, that 3 month period that I was just talking about. they can file claims while you're walking across the bridge as well. So as a matter, in practicality, it is a time-consuming event. It's something that if you can't avoid, it might not be a bad idea to avoid, and sometimes it's cost-effective to avoid it.
And that's where the living trust comes into play for so many individuals. And as part of forming a living trust, does a person need to get an attorney involved in preparing and drafting documents for them, or can they go out and do this on their own?
There are a number of programs out there that deals with trust. I would be more comfortable if an individual executed their own will as opposed to a trust, because there are a number of things that you have to do in regard to a trust. But I think it's important to also indicate that not only, I think, should you have an attorney prepare a trust, but you need to have a competent attorney, because the trust is becoming so complicated in regard to tax advantages and all the other alternative ways to do it. I mean, there are a number of different types of trusts. Number one, the first thing is, you need to have the attorney to prepare the trust, which that set of instructions I was telling you about. That's important. You need to make sure that those instructions are well defined, accurately meet the client's desires, and are written in a way. Just for instance, today I was just learning that there are certain provisions in a trust that are void in ab initio, meaning that they're void from the very beginning. They can't even be effective, and a layperson probably wouldn't know that.
Right.
Okay.
And if it was a bankruptcy attorney who doesn't do a lot of trust work, may not be aware of those statutes either.
Absolutely. And so you need to be able to have a competent attorney, competent estate planning attorney, to prepare the trust. And then perhaps most importantly, and sometimes neglected a lot, is the funding of it. And again, you've got this pretty box, but if you don't have the assets in the trust, you've just wasted your time and your money and your effort. And so that's it. And then also, in addition, when you actually administer the trust, that's important to have a good trustee and a good estate planning attorney to be able to do that, because there are certain advantages in regard to taxes, distribution, when the distributions are made, the income, whether it's retained or whether it's distributed, and who it's distributed to and how it's distributed. So those are the kind of things that a good attorney would do. The other thing is, I was mentioning earlier about the different types of a trust. You can have a revocable trust, which is a trust that you create during your lifetime,
right,
and you can change it. You can put assets into it, you can pull assets out, you can change the instructions, you can change the trustee, you can change anything that you want, as long as you're competent and alive, obviously. The other one is an irrevocable trust, and there are some substantial tax advantages for that, creditor protection and everything. But once you identify these instructions and once you fund it, you can no longer control it. You can no longer benefit from that. So obviously you need to make sure those instructions.
Very clear you want to do an irrevocable trust.
Right, exactly.
Now, you mentioned a trust may be used to pass assets on to heirs who we would think of as the beneficiaries of the trust. Typically this would be children, surviving spouse, so on, perhaps even charities. Is the person who establishes the trust, the creator of the trust, which we would legally call the grantor, are they required when they set the trust up to tell the beneficiaries, hey, you're in my trust and you're going to get X% or a specific dollar amount when the trust terminates?
No, they don't, which is one of the advantages of a trust. I mean, you can change it. Again, if it's a revocable trust, you can change it. So if somebody becomes perhaps not as favored as they once were within the family, then you can change that, and then obviously there'd be no hard feelings, because you do not have a duty. Everything that the trustee, the grantor, everything that he or she does is confidential until it's actually distributed. And so as a result, you do not have an obligation to tell them. There is no public reading of a trust. There's no public reading of a will, but there's no public reading, or basically the trustee's duty is to identify the beneficiary and make distributions pursuant to that set of instructions. But until that time occurs, then it's perfectly and completely confidential.
Good. So that's another reason it's popular, because of the confidentiality component of the trust.
Absolutely.
Well, Tom, when you sit down with a client and you're talking to them about estate planning, how do you determine, what are the factors you take into consideration to determine if a trust is the appropriate way to go? Should they be doing a living trust? Should they be doing a will? Or something else? What are the things you look at?
Well, first thing I wanted to find out is what is happening with the client. Because that's the primary concern is, does the client have the assets to sustain him in his standard of living, or her in the standard of living that they're now living. I always tell clients, don't worry about your children or your heirs or whatever. First, worry about yourself. Secondly, worry about your lifestyle, and don't worry about taxes or house distribution or anything like that, because that's the primary goal, is the client him or herself. After we determine that, then obviously we look at the value of the estate. If it's great, then obviously we have to probably do much more estate planning in the sense of tax avoidance and the like. We also contact the client and find out what kind of desires they want. Do they want to make the distribution to be made immediately upon death, or do they want them to bring it out 20, 30 years?
Right.
And do they want to put any conditions on that? Do they want to take a look at the considerations of the income? Do they want to make income distribution during the time that the trust exists to the beneficiaries? Do they want to retain the income? And then the tax consequences of that, because retained income in a trust is taxed at the highest rate. And so you probably would want to go ahead and make distribution, even though you may not want to make full distribution of the principal. The other things you want to do is think about, well, what will happen to your beneficiaries? What happens if they die? Where do you want it to go? What happens if they become incompetent? And again, when you talk about incompetency, you may have to consider the fact that they may be entitled to some government entitlements, and then by bringing this newfound money in, you may disqualify them. So we want to be cautious of that. What happens if they are involved in some litigation during the time that they receive this distribution, whether it be a divorce or a lawsuit because they've hit a school bus or something like that? Those are the kind of things that you need to consider. Even what happens if they become incarcerated? What happens if they become medically institutionalized? So there's a number of things that you want to look at in determining whether or not a trust is the appropriate place. Clients have come in and asked for a trust. When we looked at it and actually analyzed it, we realized they really didn't need a trust because they could do these avoid probate with the POD and the beneficiary designations and the like, and that's a lot cheaper. But sometimes, and a lot of times for that matter, they could sure use a trust, and they can sure benefit from a trust. And once we look at this, and once the client actually realizes that, then I think it's pretty easy to show them the real advantage of it.
So it sounds like there's a number of factors that the person needs to take into consideration even before they would go to see their attorney. And once they get in front of the attorney and have this discussion, there may be more factors identified, and it really would, it sounds, come down to each person's individual circumstances as to whether or not doing a living trust, including some of these various provisions, would be the right approach to take.
Absolutely.
So it's not just a cookie cutter, let's all run out and get living trust.
That's exactly right. That's exactly right. I mean, a trust isn't for everyone, and a cookie cutter trust is not right for anyone.
Well, Tom, if a client comes in and you determine that a living trust is appropriate given their circumstances and their desires, after you've drafted that for them, do they still need a will? And if so, why would they need a will?
Absolutely, because there are certain assets that you do not want to put into a trust, or that you cannot put into a trust. But for instance, an automobile, we don't generally put in automobiles into a trust because of the liability issue. There are some other assets that you don't want to put in a trust, and you can't. For instance, an IRA, you cannot. You can put an IRA. You can make the beneficiary. Let me say that you can make the beneficiary of an IRA a revocable trust, but it has to be a special type of trust. It can't be your run-of-the-mill, tear out the book living trust. It has to have special language in there. So that's another thing that you have to be very careful for. Otherwise, the beneficiary would not be designated properly, and if you have immediate payout for the IRA, which is
a lot of tax consequences.
Yes. Correct. And so you have to look at all that, and it takes, again, a competent attorney and a financial planner. I think the best estate planning that you can do is if you have a team. And regardless of the value of your estate, I think the best really, because if you have a competent estate attorney, you have a competent banker, you have a competent insurance person, and a competent financial planner. And I think with those four individuals, I think that you make the best decisions, and because you're giving the advice from all four of them, and even though, and hopefully they won't all totally agree, you'll be able to glean the best from all four of them and be able to come up with the best plan.
And they can incorporate each piece of their knowledge into your overall plan.
Absolutely.
Well, one of the things you mentioned earlier was creditor claims against your estate. Can people use a living trust as a way of shielding assets from a creditor either during their lifetime or at their death?
I'm going to give you a typical lawyer answer, yes and no. Yes, you can. For instance, you can use a spendthrift provision to prevent or at least exclude creditors from beneficiaries in a revocable living trust. Obviously, at that time, though, when you're starting to make a distribution, perhaps the grantor has died and now it has become irrevocable. But you can do that. Now, you do have to be concerned about the Uniform Act in regard to defrauding creditors. And so you cannot actually, an individual cannot actually put the assets into a revocable living trust. Revocable meaning you can change it, living meaning that you created it during your life. They cannot put it into a revocable living trust and safeguard those because you still have full access to those. Now, if you put it into an irrevocable trust, a trust that you create while you're alive, but you fund it and then you no longer have any benefit or control over that asset, and then creditors come and attack you at that time. As long as they cannot prove that you put those assets into the irrevocable trust to defraud them or to exclude them, then you can, in fact, safeguard your assets that way.
And what about at death, when the trust is terminated and there are claims that come against the estate? Can the living trust be tapped by creditors at death?
That's one disadvantage of a trust, because during a probate estate, we have this 3-month period that I talked to you about, that you're walking over this bridge for 3 months. During that time, creditors can file a claim against the probate assets. In regard to a revocable trust that obviously becomes irrevocable upon your death, that 3-month period does no longer exist. So they have the right, as long as the assets are in existence, they have the right, as they would, like the statute of limitations would for any type of debt. So that is one disadvantage of a trust, that you extend the creditor period to be able to lay a claim against the trust as opposed to a probate estate.
Which gives you just 3 months to get your claim in.
Right.
Kind of along those same lines, we often hear about will contests where a beneficiary of a will feels they haven't been treated fairly, they didn't get their fair share, perhaps they were totally left out of the will altogether, and they'll contest the will in court, and sometimes they'll win. But is it possible for someone to contest a trust? Dad writes a trust up, but he leaves son out of it.
Yes, it is possible. I think it's more difficult to challenge a trust than it is perhaps a will, because while they do have certain requirements that are mutual to each other, the requirements of actually executing a will is not as perhaps defined as it is for a trust. A trust can be created fairly informally, but yes, you can. In fact, there's the provision I just learned today that they just passed, and it's in 2003, was actually prohibits an individual grantor to actually place a term in the trust that states effectively, if you decide to try to contest this trust, either a provision or the entire trust itself, you cannot recover, you can no longer receive the benefits of this trust. So if you have a provision in your trust that tries to inhibit an individual beneficiary from contesting the trust, that's going to be deemed void and not enforceable.
Interesting.
Yeah.
Another big decision that a client has to make as they form their trust is who can and who should be the trustee, because there are a lot of duties involved and expectations placed upon a trustee. So as you advise your clients in making that decision, Tom, what are some of the things you tell them when they're deciding who should be the trustee?
Well, I think the first thing is you need to look at the qualifications of the trustee. I mean, and the value of the estate. In looking at the qualifications of the trustee, you need to see, is a trustee competent? So, for instance, you could have a friend, you could have a spouse, or you could have anyone as your trustee, but you got to look at how this trust is going to be administered, the value of the trust, when you want it distributed, the income tax and perhaps even estate tax consequences, the investment opportunities and requirements. So you need to look at a trustee who is competent and qualified in order to handle all those requirements that your trust is going to have. The ability to act in the best interest of the beneficiary, you need to look at that. If the trustee is perhaps someone like a financial advisor or something like that, and perhaps is more interested in gaining commissions on churning the accounts or something like that. Obviously, that's not the kind of trustee you want. You want to have somebody who's actually looking out for the best interest of the beneficiaries of the trust. You also have to have a trustee who knows the needs of the beneficiaries, someone who's familiar with your beneficiaries and knows what's required of them. Knowledge of the subject matter of the trust is another requirement for the trustee to have. He has to know trust. He has to know the administration of the trust. He has to know tax law. He has to know insurance, perhaps. So obviously, there's a lot involved there. Experience. Obviously, there's no substitute for experience. How do you get experience? You just got to go through it. So you need to look for the trustee who's experienced, or at least someone who is teamed up with someone who's experienced. The availability to serve, the proximity to the trustee, or to the individual, the grantor in his life, and obviously a lack of conflicts. You don't want to have a trustee here who has a conflict of interest with his or her interest and then the trust benefits.
So that is a very critical decision, and people need to think on it very seriously before deciding who they name as trustee. Well, as we kind of wrap up, Tom, I guess my last question for you this evening would be the decision on cost, because that is another factor that I hear people say as well. What's it cost to do a will versus doing a trust, and how would you respond to that?
A will is a lot cheaper. We do wills for $100, and that's $100 for husband and wife. It's not each, it's $100. We also do a living will for them. A trust, generally a trust package, which would include generally two trusts, a trust for the wife, a trust for the husband, two wills. They're called pour-over wills because they're important to have two. And so we'd have a pour-over will for the husband, a pour-over will for the wife. And what the pour-over will does is basically gathers those assets that were not placed into the trust, whether they're automobiles or a small checking account, so that you don't have to sign trustee at the grocery store and they wonder if they can accept your check or something like that. So you have those, and then those will go through probate, and if I've done my job right, they'll be less than $25,000, and we can avoid formal probate, and then take those assets and pour them in to the trust and have them be distributed pursuant to the terms of the trust. So you'd have two trusts, two wills, two power of attorneys rather, and a power of attorney is basically what happens. You would give somebody, presumably your spouse, this authority to sign on your behalf. So if you're out of town or if you become incompetent or something, they would have that authority. And so there's a number of documents that would be included with that. The one real advantage of it, though, is if you would have an estate of, let's just say, $100,000, and that's a lot of money, I'm not trying to minimize that, but let's just say you have an estate of $100,000, attorney's fees on that, if you go through probate, presumably reasonable attorney's fees would be 6% of that, which is $6,000. So it's one of those things, pay me now, pay me later. So
exactly.
Sometimes it's really an advantage.
Well, thanks, Tom. I think this has been a very informative discussion. And viewers, thank you for tuning in. Be sure to join us next month. Our show will be on Wednesday, June the 16th, and my guest will be Dave Wirtz, a chartered financial analyst, and we'll be talking about investments and the market outlook. Thanks again for tuning in.
You're watching Whitewater Educational Television, Cable 20, a service of Whitewater Community Television.